platforms. All right. Now we're going to admit, welcome to this. Today is October 16th. It's a Saturday. It's at 10 a.m. If anybody sees my lips moving and can't hear me, if there's some way you can let me know, you can do that through chat. Today I'm here with Mr. David Greenberg. Before I give you a more formal introduction to Mr. Greenberg, I'd just like to let some people know, anybody who's listening in, know that we have a week coming up that is as of October 19th through the 26th of October, and it's referred to as Estate Planning Week. I didn't put it together myself, but there are people who put it together, and apparently those who are promoting this week are also offering a discount for those people who would like to do their living trust, their wills, their powers of attorney, anything of that nature. So be aware that that's coming up. And the reason I mention it, of course, is that I do that area. That's my practice area: living trust, wills, and powers of attorney, anything of that nature. Probates, if somebody didn't quite get around to doing their trust, and now we're facing a probate situation which requires going to court and resolving all the issues that the person who passed away did not resolve during his or her lifetime. Please, if you have any questions regarding that area of the law, don't hesitate to give me a call. You will have all my contact information available by virtue of going either onto YouTube or onto Facebook or through the Zoom process. I do not have anybody asking questions right off the bat, because perhaps you don't know a whole lot about David Greenberg. Let me introduce you to this gentleman. He is an attorney. He has a bachelor's of aeronautical engineering from Rensselaer Polytechnic Institute from 1965. His juris doctor was through the University of San Diego School of Law in 1973. He was a United States naval officer from 1965 to 1970, including combat command with the United States Navy River Patrol Forces. He's admitted to practice in the state of California. He's also admitted in the Central and Southern Districts of the United States Federal District Court, the United States District Court, United States Tax Court. He served as an arbitrator and judge pro tem through San Diego courts system. He's the legal editor. He's a legal editor or the legal editor for King's Guide to Offer and Compromise, a treatise for attorneys. And he can tell you exactly what this offer to compromise is all about in order to, in finer detail than I could, but essentially to resolve your tax liability. Currently, Mr. Greenberg is representing individuals and businesses with regard to tax matters. For example, resolution and settlement of account balances due for state and federal income and payroll tax. He's in tax court for any litigation that may be necessary. Discharge of taxes and bankruptcy is an area that he specializes in, and he does, of course, audits as well. Everybody, and I know there'll be many people looking at this in the other platforms like YouTube and Facebook, but here I present to you David Greenberg. Mr. Greenberg.
Well, good morning, Ruben. And first of all, thanks very much for inviting me to participate. I would like to start by commenting on one of the many adverse consequences of the COVID crisis. Many people out of work, of course, availed themselves of unemployment insurance benefits in California through the Employment Development Department. And those benefits were supplemented by federal unemployment benefits to the extent of $600 per week. And so therefore, anyone eligible for those benefits was receiving a significant amount of monthly income, which we certainly would want them to have to be able to pay their necessary living expenses, pay rent, and put food on the table. An unintended consequence that the recipients of these benefits may not have contemplated is that all of that income is taxable. So when it's time to file a 2020 tax return next spring, the agencies that provided the unemployment benefits will be providing 1099s, which have to be included in the tax return prepared for 2020. Because it's extremely unlikely that anyone made any estimated tax payments based on their receipt of these benefits, these people are going to be facing a tax bill that they very well may not be able to full pay when it comes time to file the tax return. And of course, if you can't full pay and the tax return gets filed, then failure to pay penalties and interest start to accrue. And so therefore, that puts them in a position of that millions, actually tens of millions of Americans find themselves. And that is they find themselves in a situation where they have a tax bill and they just can't pay it. And so what we do here in my firm is we assist businesses and individuals in dealing with those balances to resolve the account with the best available remedy in order to prevent invasive collection procedures such as wage levies and bank levies. And the bottom line is that anyone with a tax balance that they can't pay shouldn't panic, because it is in fact manageable. It's just a matter of carefully identifying the correct tax balance and then taking a very detailed look at the financial ability to pay the tax to determine what the best means available is to resolve the liability. One fundamental concept in play that applies to both the state of California and the Internal Revenue Service is that each taxing agency has to allow a taxpayer access of enough funds from income to pay necessary living expenses in all those categories of living expenses that we all have. So as an example, if someone is making $5,000 a month, and if we subtract from that the tax that they're paying on that monthly income, and if we subtract from that all they're paying for necessary living expenses, if all of their income is eaten up by these calculations and there's zero left that could be devoted to the payment of taxes each month, then they're in the status of what's known as currently not collectible. And what that means is the tax bill remains on the books and continues to accrue interest, but neither taxing agency can take steps to engage in collection. The FTB and the IRS will periodically check finances to see if there's any change in the ability to pay, but in many instances, getting the status of currently not collectible can be an advantage. In that same example, if the calculation shows after deduction of expenses and current taxes that there's $100 a month left over that could be devoted to the payment of back taxes, then that would define the extent of any potential exposure with regard to a payment plan. The financial calculation also applies to evaluating whether an individual is eligible for an offer in compromise. And offer in compromise is the concept that is seen very frequently on late night TV ads by what we refer to in our office as offer mills. In other words, they advertise that they can get you the so-called pennies on the dollar.
David, do you mind if I interrupt for a moment?
Yes, sir.
Because before you get into the details of offering compromise, I would like to go back a step if I can, because I was curious as to these unemployment benefits enhancements that have been provided by the government. Are they taxed as though it were regular income? Is that how that's done? Do you know?
Yes, it's ordinary income.
Ordinary income.
Yep.
Okay. And That was one of my biggest concerns, so that it would be really good for people to realize that that's on the not too distant horizon, uh, in light of the fact that they'll be needing to prepare their tax returns by April 15th of next year,
Yep.
if there are no changes.
One
Okay.
other footnote on that, Ruben, and that is that that $600 a week supplemental federal benefit, which it goes to about 2,500 a month if you do the correct calculation, cannot be considered in means testing in a Chapter 7 bankruptcy. There's a specific prohibition against including that in means testing. So that's an important consideration in evaluating the extent to which Chapter 7 relief would be appropriate for those tax periods that would be eligible for discharge, which is this topic, another topic to discuss.
Okay. Okay, great. Thanks for answering that question. Yeah, I want to know a little bit more about offering compromise.
All right. The companies that advertise hire people who are very skilled salespeople. They don't know too much about tax, but they're expert salespeople, and they can convince an unsuspecting taxpayer to send them money, which is their primary objective in the process. And I actually saw a guarantee that they presented to one of my clients who was a refugee from one of those companies. And the guarantee says that they'll file the papers. It has nothing to do with the result. And that's the problem, is that they don't evaluate finances to determine, first of all, if the taxpayer is eligible for an offer in compromise. And second of all, if the finances would justify a reasonable amount with regard to settlement. So the proper way to deal with the concept of offer in compromise is to consider it within the spectrum of all remedies that are available to a taxpayer to deal with a tax balance. I've already touched base with regard to currently not collectible and payment plans. And the offer in compromise, of course, can be a viable option. We're very, very careful to do a detailed evaluation to determine, first of all, if an offer in compromise would be considered by the IRS, and second of all, what the likely amount of the offer amount should be. And when we do that calculation, if someone's a W-2 wage earner and they owe $80,000 and the settlement would be $25,000, they're not going to be able to come up with $25,000. And so therefore, even though on paper it could work, in reality, it wouldn't work. So it's important to carefully evaluate finances in advance to determine which tree we want to bark up in order to get a good result for our client. And I know your firm does bankruptcy, and that, of course, can be a very, very powerful tool to clean out dischargeable tax. In fact, my most recent case, an unfortunate woman owed $200,000 in taxes, and we were able to get it all discharged. And so that was one of the nice thank you notes I got, was from that particular client. It's doable. Most people walking down the street have no idea that taxes can be dischargeable in bankruptcy. Most people think that they can't, but that's far from true.
Right. And this turns on the how old they are, certain things like that. There are a lot of factors that come into play.
Yeah, there are 3 timeline criteria that define the dischargeability of a tax debt. And the first one is referred to as a 3-year rule, which means that the due date of the tax period in question has to precede the bankruptcy by at least 3 years. The second rule, which is a 2-year rule, is that the taxpayer has to have filed the tax return more than 2 years prior to the filing of the bankruptcy, excuse me. And the third timeline criterion is a 240-day rule, which means that the tax has to have been assessed by the IRS more than 240 days prior to the filing of the bankruptcy petition. There are 2 other non-timeline criteria that are in play. One is there can be no evidence of fraud in the preparation of the tax return, and there can be no evidence of willful evasion of the payment of tax. Now, the timeline criteria on their face seem to be fairly straightforward, but they're not, because there are certain events that can occur which will toll the running of the 3-year period and the 2-year period that would substantially change the eligibility date for the discharge. And this has to do with the pendency of bankruptcy, pendency of collection due process hearing, or any event that legally precludes the taxing agencies from engaging in collection. And that is something that has to be carefully looked at, because if you just go by those 3-year and 2-year and 240-day rules and you don't take into consideration the tolling events, you're asking for trouble and you may not get a discharge.
And as a matter of fact, I think you mentioned to me that you knew of an attorney who filed 1 day too early.
Yeah, we were discussing that. He filed 1 day early, and therefore his client was not eligible for discharge.
Oh, that's sad. And I guess, well, I guess he's got problems as a result, I would assume.
Well, as long as he has professional liability coverage, he'll be okay.
Right. Okay. I'm hoping that we haven't lost some people as a result of being a little too technical, but I'm not getting anything on my chat. Anybody who's online should feel free to chat questions that you may have, because David has already represented to me that we can go on hours and hours and days on this discussion of Internal Revenue Service. We would like it to be more relevant and more, how should I say it, contemporary perhaps, in that there was another issue that you wanted to raise, David. What can be done if a taxpayer disagrees with an IRS audit determination?
Yeah, there are a number of provisions available to a taxpayer in those circumstances. The first is to request an appeal directly to the IRS Appeals Office, and so that evidence can be presented and arguments can be put forth to overcome the conclusion that the auditor may have arrived at. If that's not productive, then what will happen is that the IRS will issue what's known as a statutory notice of deficiency. And this is a notice of intent to assess the additional tax calculated by the auditor. In that notice, there's a specific provision that the taxpayer has 90 days within which to contest that potential assessment by filing a petition with the U.S. tax court. And that's something that I will routinely do in a situation where we feel that there's been an egregious error at the audit level. And what transpires, of course, is we file a petition with the tax court, which is located in Washington, D.C., but which hears cases here in San Diego. And a few months after the filing of the petition, the case is set for yet another appeals conference, at which time the evidence and the arguments can once again be put forth and hopefully lead to a resolution. My experience has been that 99% of the cases resolve at that tax court appeals conference. It's an unusual case that has to go to trial, but going to trial is an available option should it be in the taxpayer's best interest. So you've got these different levels of procedures that are available to contest what may very well turn out to have been an error on the part of the IRS.
Okay. All right. Let me see something here. Nope, I thought I had another question from somebody else. But let's see what we can do here. There we go. All right, I put this on speaker mode so that when you're talking, everybody will have a great view of you. That's all. It's just a little technical point. All right. David, I had another, I have many questions actually, and consistent with this, the court, there are a lot of people that are terrified that IRS is an ogre or a monster. The IRS is just there to get your money, and there's no real good solution available. And of course, that's not true. But I have also heard the story that the Franchise Tax Board can be even tougher than the IRS. And so I've got people who have come to me and said, I've got this problem. I said, I'm sorry, I'm not an IRS, I'm not a tax person. And I've referred them to other people, but I can also refer them to you. They are terrified by the Franchise Tax Board as well as the IRS. Is that, it's not really within the scope that we had discussed that we would be talking about, but have you found that to be the case or not?
Yeah, that's a good characterization, Ruben. The Franchise Tax Board is quite aggressive, and I think it has to do with just the state of the California budget and the need for revenue from all potential sources. But they are quite aggressive, and when a client comes to see me and they have both IRS and Franchise Tax Board issues, we focus first of all on getting that FTB under control, because they will just go for the jugular in terms of enforced collection if proper negotiations are not completed to get some sort of account resolution. But I agree with that. They are far more aggressive than the IRS.
Understood. That's what I thought was the case. What about, can you tell us a little bit about 941 taxes and how
Yeah,
does IRS
yeah.
handle that?
941 is payroll tax. And what transpires with the average small business is that they, of course, have an obligation to make periodic payroll tax deposits and file quarterly payroll tax returns. And in the event that there's a shortfall in revenue for the business, in order to stay operating, will pay the rent and pay salaries, and the payment of the payroll tax goes to the bottom of the list. And under those circumstances, and I've had this related to me countless times, the owner of the business says, well, I didn't pay it that 1 month because I knew I would get caught up. And then the second month goes and it snowballs and snowballs until they've got thousands of dollars of tax liability. The IRS is very, very aggressive with regard to recovering payroll taxes, because that's the government's money that the employer has withheld from an employee's paycheck. And so it's referred to as trust fund money, which it truly is. Now, there are ways to negotiate resolutions on behalf of in-business companies in order to get them, first of all, compliant on current obligations, and second of all, getting some sort of payment arrangement in place. But the important thing is that the employer cannot continue to accrue payroll tax liabilities once the IRS puts the microscope on them, because the IRS has standing to go in and put a padlock on the business and stop the bleeding. And they will do that if it's an egregious situation. Another significant import of or consideration with regard to payroll tax, if the employing entity is, say, a corporation, and it's the corporation that owes the payroll tax, the IRS has standing to assess what's known as a trust fund recovery penalty against responsible persons within the corporation who made financial decisions. So what starts out as a corporate tax liability is transformed, subject to certain reductions in the exposure, to a personal liability. And then the individual responsible person within the corporate structure is personally obligated for those taxes as though it were income tax. And one very important point about payroll taxes, either on the part of the employing entity or on the part of the person assessed with the trust fund recovery penalty, they are not dischargeable in bankruptcy under any circumstances.
That was going to be my next question. So that the 941 taxes cannot be wiped out in bankruptcy. And And so somebody's going to be stuck with that, and they're going to need, in those circumstances, they can look at an offer in compromise, right?
Oh, yeah, and then this is a fairly standard scenario that we put together, is that if you know, essentially the business can't respond and pay the tax, so the trust fund recovery penalty is assessed. The individual walks in with a you know, say $100,000 liability, then we look at offer and compromise, and we go through the very exhaustive analysis that I discussed just a few moments ago to see if it can work. And in many instances, it does.
Oh, okay. Okay. What if do you ever have that scenario where somebody is just, I relied on my business. My business was my source of income. It shut down. I really don't have any source of income right now. No real true assets. Maybe a house that's over encumbered, and they're just so frustrated that they don't seem to find any resolution. Sounds like a tough case, right? Tough nut to
Well,
crack.
it may turn out to be quite manageable, because if income is limited and there's no equity in assets such as the personal residence, then the financial profile for a settlement or offer and compromise would be very favorable. And so that would be something that we would look into very, very carefully. And we've had success in those types of situations in the past.
Oh, good, good, because I've talked to people who said, "Well, I can file bankruptcy, but it's not going to wipe out my business taxes." And I told them, "Yeah, that's right. However,
That's true.
your next step is talk to a specialist in offering compromise,
Yep.
and that's not me. That's somebody like David Greenberg."
Okay.
So, okay, David, I do know that I don't have a series of questions at this moment, but I do have a question. Another area that we need to go into. And hold on a second. Is there any way to avoid IRS penalties?
Yes, the concept of penalty abatement does exist, but the threshold that has to be met is very substantial. In order to avoid a penalty or get it abated to some extent, there has to be a showing that a traumatic event or experience occurred that was of such magnitude that it impaired the ability to file on time or pay on time. Examples of this are serious illness or injury to the taxpayer, same condition with a family member or loss of a family member, psychiatric problem, drug addiction, all those horrible things that we really wouldn't want to have happen to anyone we care about. And if we can
And
show
probably
it,
today, David,
but
probably today, COVID situations may come into play.
conceivably, but the financial inability to pay a tax in and of itself is not a substantial or adequate basis for penalty abatement. Um,
I'm sorry,
and
David, I have to interrupt you one more time.
yeah,
What is abatement for those who may not know?
okay, well, let's assume you've got a $20,000 tax bill, and the failure to pay penalty and the failure to file penalty is $5,000. If we have sufficient facts that are sufficient to generate an abatement or a reduction of the uh, penalty to, in this case, we would want to go to zero, we file a petition for abatement, which is just reduction or elimination of the penalty.
And at some juncture, the IRS can actually say this is abated and there's no liability.
Yeah,
Essentially.
that's correct. The most interesting case I had with a successful abatement was an individual taxpayer who owed a substantial amount of money, and of course was subjected to penalties. And he related to me that he had the funds available to pay the tax, but he couldn't remit them to the IRS because his son had been indicted for murder.
Mm.
And he therefore took all of his funds and hired a highly skilled and expensive criminal defense attorney to protect his son from the consequences of a murder conviction. And that I was able to convince the IRS that that was a valid basis for abatement, and they did abate those penalties.
Excellent. Great job. What this still kind of stays on my mind because I'm trying to envision the scenario where, I know for bankruptcy purposes, and I know you do that for your elimination of tax liability on in bankruptcy. Um, I've been faced with students. Students will come to me and they'll say, I can't pay, and their student loans. That's not exactly an IRS scenario or at all. But I'm assuming that it follows a similar type path as the IRS.
Well, the thing with student loans is that the presumption is that it's not dischargeable. But
Correct.
if the finances of the loan recipient are so thin, the worst example, of course, someone living in the car, then there's a pathway to get student loan obligations discharged. But it's a very narrow path, and it's
Correct.
an area of interest in Congress because I keep seeing references to student loan relief, either partial or complete. And taking it out of the preclusion from being subject to a discharge in bankruptcy.
David, I usually tell people right off the bat that we're going to go for 30 minutes, open it up for questions. We're beyond the 30-minute point, but there is a question that's burning in my head and my ears maybe, and that is, would you like to discuss a little bit about what your arrangements for payment are for your fees?
Yeah, what we do is we accommodate our clients to make fee payments rather over a period of time,
Okay.
because the average client who comes to see me is not flush with cash, and so
Otherwise, they may not be in that situation.
yeah, yeah. And our fees are reasonable, but in many instances it's beyond something that could be paid right off the bat. And so what we do is we work up a monthly arrangement on the payment of fees. And what we request that the client do is to pre-authorize a monthly debit by way of a debit card that they give us. We do that explicitly in writing to ensure that they've given us the proper consent. And then each month our accounting system automatically debits the amount that they've agreed to. That works well, and it enables people to have the benefit of the relief that our services provide and still be able to afford it.
That's fantastic. That's good to know. I want to mention to anybody who might be listening in on this that when, when we first talked about doing this talk, somebody mentioned to you from my office that how about loopholes in the tax area? And you kind of said, no, we're not going to go there. And I got the impression that there's this whole big industry that works on that preys on people who want to know about tax loopholes. And that's probably why you didn't want to go there. Am I correct?
Well, yeah, and also it's you know tax planning and strategies in order to avoid or reduce tax it's a peripheral consideration in my practice. I'm there to represent the taxpayer when they're in a position where they're behind the eight ball and they don't know what to do. I defer to skilled and experienced CPAs to do the actual detailed tax planning in terms of how to reduce future taxes. Just that simple.
Excellent, excellent. That answered my question, and it was left up in the air for me as to why you might want to not go there. It's really a CPA type question,
Yes.
in reality. Okay, David, there's so much, and like you said, you can talk hours on end. Is there something else, an area that we may not have mentioned that seems to be cutting edge, perhaps that
Well, I think I can conclude my comments with the the psychology of someone who, the psychological state of someone who owes taxes that they can't pay. First of all, they seem to think that they're the only person in the world that has this terrible problem when there are tens of millions of people who have the same problem. Second of all, they feel that there's no way I'm ever going to get out of this. I'm going to be paying this for the rest of my life, which is not true. There are all the remedies that we've discussed this morning, plus another factor in play with regard to the IRS. There's a 10-year statutory collection period, which means that once the IRS assesses a tax, they only have 10 years to collect it. It's otherwise abated to zero. Now, there are some exceptions to that that hardly ever come into play. And so it's, I encourage my prospective clients when they leave our first meeting to walk out with one concept, and that is that it is in fact manageable and it can be worked out in a means that is affordable to them.
And they can go on with their lives, ideally.
Yes,
Okay.
yes, absolutely.
Is one of those circumstances where it may go beyond 10 years? Is that for example, the installment agreement? Is that
No,
something?
no, installment agreement won't go beyond 10 years, but the IRS, of course, has standing to and will file notices of federal tax liens. And they can reduce the lien to a judgment within the 10-year statutory collection period. And then they have a judgment that they can enforce for another 10 years.
And keep renewing every 10
keep
years.
renewing. And so for 7 and 8 figure liabilities, that's what they do. But the average consumer is not going to have that scope of liability.
Okay. Do you have any experience, David, in the area of people who pass away owing tax liability?
Yeah, what happens is that the estate of the decedent is liable for the taxes, and if the decedent leaves no estate, which is not uncommon, then the liability is of no consequence or no value to the IRS. There's another.
Essentially, it's extinguished. And
yeah.
The result of the passing of the person.
Yes. But there are a lot of exceptions to that, but that's the general concept with a wage earner with no substantial estate left behind.
Excellent, excellent. All right, I'm trying to think of questions that other people might ask, but they had their opportunity to join us. They have your contact information, and if they have you see, here's the thing. I think that there are a lot of people afraid to talk to tax specialists because they're thinking, I'm going to go over there and they're going to ask me for a ton of money that I don't have, and I don't know what I'm going to do. Am I wasting my time? And you can assure us that you will be willing to work with them and come up with a payment plan of some sort.
Sure, and just as a footnote on that, whenever I have an initial meeting with a prospective client, I never charge for that because, I encourage people to come in and see me just so that I can advise them as to what their options are. Now, if they choose to have me represent them, that's fine. That's fine. But if they don't, at least they have some knowledge that something can be done to help them out.
Okay. I got a question here that I'm not too sure how tax related it is. The question is, what about the issue of stepped up basis when a trust is involved? Do you have any knowledge of that area?
Yeah. I mean, it's something that's within your wheelhouse in terms of estate planning, Ruben. But as a practical matter, I occasionally get a client who says, I want to transfer title of my home to my daughter. And I find out what the basis for the acquisition of the property was and what the current value is. And then I advise them of the capital gains tax consequences of an inter vivos or lifetime transfer. And then I point out that if it's transferred as a consequence of trust administration, then the basis is stepped up so that the recipient of the property is not going to face this huge capital gain liability in the event that they choose to sell it in the near term.
Right. And by the same token, there would not be an increase in the tax, the property taxes.
Correct. Absolutely.
And that's, I mentioned that to clients that that is a different type of tax issue. What we've been talking about is IRS tax issues. And so that's very helpful. I hope that answers your question, Greg. All right. Sometimes these sessions go on and on. I don't know if you're aware that I had a session, David, on immigration and criminal law not too long ago. And there was substantial interest that drove the meeting on our normal talk on for quite some time. There are people who are undocumented who have tax liability. They get a TIN number, they pay taxes through their taxpayer identification number, and now they have these tax issues that they have to deal with. Uh, they're not entitled to a tax refund, is my understanding, if they're not legally documented in the United States as,
Yeah, that issue is up in the air. I've always argued that they are. If they're subject to the Internal Revenue Code and they pay taxes as a consequence of that, that shouldn't disqualify them for receiving a refund. But that's a very contentious issue. It's not settled.
okay, it's not settled. That's
No.
all right. Okay, good. All right. Well, David, any final words?
Once again, thanks for inviting me to attend. And I hope that whomever might be watching the presentation, hopefully will walk away with some useful information. And we've described the type of service that I provide, and there's a catchphrase on my website which says, "Don't let the IRS ruin your life," and that is the process that we invoke in order to achieve that goal.
David, it's been a great pleasure. I'd say it's been an honor to have met you this way and know more about you. I just hope that I personally will not have to contact you for personal concerns. But if I do have any tax liability concerns, you will certainly be at the top of my list as a person to contact. And let's stay in touch. Let's keep in touch. We can let each other know what's happening in our respective areas of practice. I'm reminding people too, taking advantage that October 19th through the 26th of October this year is Estate Planning Week. And we are wide open to offer some very good rates on your living trust package, your living trust documents, which also include powers of attorney and a forward will. That's all we have for today. David, it's been a blast.
It's been my pleasure. Thanks very much, Ruben.
Okay, you take care. We'll be in touch.
Bye.
All right. Bye now. Let's go here and